As on today, 12th December 2007, a constitutional bench of Supreme Court of India consisting of Chief Justice K.G. Balakrishnan, Justice R.V. Ravindran and A.M. Panchal, it has upheld the importance of scientific texts such as brain mapping and narcoanalysis. They urge the investigating agency to adapt these new techniques to fight the upcoming roar of terrorism and to deplete the use of unethical means of extracting the information through third degree and encounters. So this ERP response, they are highly sensitive, they are specific to the probe, to the person and to the crime. And the time resolution we measure in the order of millisecond. Before an individual makes an attempt to conceal, for him to make an attempt to conceal, it takes minimum 2 seconds. We are measuring in the order of millisecond. So the time resolution here is very important and it can be easily repeated. They do not cause any discomfort even if it is continued for a long time. And it has a built-in artifact program. The people usually ask that when such electrodes are being placed on the individual will have tension, he will have anxiety, and because of which the individual may develop some waves that may be generated in the brain. But the brain, the machine itself has built-in artifact elimination program. Such anxiety, such a fear can be eliminated with the built-in artifact elimination program. And usually it doesn't arise because the moment he comes, we don't take him to the room and fix him with the machine. Usually we have preliminary test interaction, which is more important than the actual testing procedure. We should give him an opportunity to speak, what he speaks, and he should be told about the method. The consent should be obtained from the individual. The individual should understand that these are the things that we are going to present. After all this, the individual, when he is comfortable, then we take him and fix it to the machine. So the question of anxiety will never arise. So even if it is continued for a long time, usually the actual procedure is only 30 minutes. The fixing of electrodes, it takes 40 minutes. The actual procedure is only 30 minutes. Even if it is continued for a long time, it will not cause any discomfort to the individual. And the built-in artifact program eliminates all other brain activity which are not locked to the stimulus. In Karnataka Forensic Science Laboratory, we have developed this for the first time in the country, and we have tested now more than 3,500 persons in about 2,000 cases, and we have separate profiles for accused, suspect and witnesses. The brain mapping technique was developed only because of the assistance by the Ministry of Information and Technology. I would like to thank in all my presentations the support that was given to us. I wish to thank the Ministry of Information and Technology, Government of India for funding us to develop this project, Government of Karnataka for encouraging us to carry out the project, experts from NIMHANS, expert from Indian Institute of Science, National Law School University Professor Ramakrishna, ISI for their support in carrying out this project. Thank you.
So now ultimately what is sought to be done is you are trying to dig out the facts, or you are trying to dig out the information which is stored in the brain or in the subconscious mind or the semi-conscious mind, whatever. So what if the person is having some illusions, say some fantasies, and they are so deeply rooted that he starts speaking of the fantasies as though they were a reality?
Yeah. Having.
Then my question is with respect to narco. Because,
fine. With respect to narco analysis, also I'll let you know. So this drug, sodium pentothal, is a drug which does not cause any illusion nor any hallucination. If a person, if at all, if he is having hallucination, even in narco analysis, he will say that this is what I felt like. This is what I wanted to have. He'll not narrate in terms of what actually happened. For example, recently, you must have been noticed that in 3 Simi people, Nasir, Azadullah from Hubli, they were arrested. So one of the person, he told us in narco-analysis, where subject them for any test.
Madam, here it would not be a case of hallucination because you have now been able to identify the person or whatever, and that would come within the meaning of section 27 of the Evidence Act. But the question is, he speaks of certain things and said even these 5 minus points, how can we accommodate them?
No, 1 minute. The drug which is used here is established that it cannot produce any fantasies, number one. Because the drug action will not produce that as an end product. No fantasy, no.
Madam, we do what is called as, we have a monitor called as a particular level when the individual really has entered into the trance, where all his thought process are blocked and he is in a disinhibition stage, as Dr. Mohan says, and he cannot inhibit any information, he starts giving out the information. And we take into consideration only that particular aspect. Whatever, the moment like it is so thin, it is so fragile, as he said, as the number goes on decreasing, he either enters into sedation stage or he may enter into awakening state. But the expertise in narcoanalysis is only in identifying that particular trance state. As you say that, he keeps on saying something nonsense, something irrelevant, not related to the crime, but we should identify. That is why we use the monitor in identifying whether the individual is truly in the state of trance, or he is in the first state, or he is already entering into the third stage. So with the help of conscious level monitoring, it is possible for us to identify whether he is just speaking like that irrelevantly or he is genuinely speaking. What happens in narcoanalysis is the thought process gets temporarily blocked. That when the thought process gets blocked, he cannot imagine. There is no fantasy. He is in a disinhibition stage. He cannot hold any information. So he starts, the information starts emerging. Because he can't think, there will not be any fantasy also. There will not be any imagination also.
Dr. is to see what is. He may say it is a fantasy, number one. Here what is happening, the verification of the revelation, right? The end result is not being found either as a delusion or a fantasy. What I am trying to say is, a kind of a verification was not there. Even now, when this information is revealed, ask a psychiatrist to react. He says it could be delusion. That is how his view is. But after verification, when the revelation itself activates the law to perform, right? Then the concept of your fantasy or delusion should get diminished. No fantasy or delusion will activate the provision of law. Only truth activates.
A bit more of an explanation, sir. I couldn't get it. A little bit more of the explanation.
You want me to tell you again?
Yes, sir. A bit more. The crux of it. The crux of it.
Let me come a little more near. What I am trying to say is, sorry for the interruption, Doctor. Right? Now, when the state is verified, and the particular the revelation is giving way for making recoveries under Section 27 of the Evidence Act, then do you call that as a fantasy, or do you call that as a delusion? So, irrespective of recovery under Section 27, psychiatrists would still call that as a fantasy. This is a big difference you need to identify. So, therefore, here what narcoanalysis we are talking about, we look for the probative truth, either by making the provision of law to activate, or adopt the provision of law to encumber the revelation at appropriate frame of reference. This is a big difference. What you said is from a psychiatrist angle. That is one angle. You go to a pharmacologist or a drug specialist or pharmacopsychiatrist. He would look into pentothal sodium. Could it produce delusion? He says no. When you use pentothal sodium, no delusion. Use amphetamine, yes, there could be. Or use ketamine to certain extent. So it depends on mainly the drug. So 2-3 different views. You need to appreciate the differences. As long as it resonates the law to act upon, there is no fantasy, there is no delusion. Thank you very much.
Thank you, Dr. Mohan. And
it's not an addictive drug. See, when an individual gets some stimulation, he may start fantasizing. But this only relaxes the individual. It relaxes his mind, it relaxes his body. So there is no chance for the fantasy also. This is not such a type of drug which can cause any hallucination, nor has any fantasies. It only relaxes. It doesn't give any type of pleasantness to the individual.
So you mentioned that during the thought process.
Put it on.
Please switch on the mic.
In the thought process, during administration of the drug, there cannot be any thought process. You said that. But if the person is so determined that he has thought prior to coming to the center, like prior to administering narcoanalysis or brain mapping, he has thought prior that he is not going to reveal any kind of information. Then what is the...
During the trance, they said that they have already undergone narcoanalysis twice at Mumbai and they had come. They were strongly suggested not to reveal any information. They themselves, all the suspects who are accused now, they themselves have undergone narco and they had come. So in spite of that, they were unable to control. Even if they have determined not to reveal, when it enters into a particular GABA site of neurotransmitters, when it binds GABA neurotransmitter, definitely they will enter into disinhibition stage, which they cannot hold. It is not voluntary.
Thank you.
Police sub-inspector. I am a police sub-inspector. I was with the terrorist for a few days. And after going through narcoanalysis test, they were suffering from headache. After 7 days also they were suffering from headache and a little bit of chakkar, I think. And one of them also was suffering from stomachache. So what do you say regarding this, sir? Side effects.
There are two aspects. Narcoanalysis done. How after? How much after? 1 minute. Now, whether the headache is directly related to the narcoanalysis, is it your presumption? Or is it the presumption made by that particular person? Because there is no literature support. Even in the post-narco period, irrespective of the length of post-narco period, these symptoms are anywhere recorded. So, only thing is, it may be a coincidence that he is informing that headache after the narcoanalysis is over. But it does not give us, some kind of an opportunity to link the two. If you are linking the two, we need to know the mechanism. We need to know precisely, yes, it is because of pentothal sodium residual concentration in the brain, he is suffering from headache, but no such reports, right? So, do not presume that it is because of narcoanalysis. So, what is emanated out of that is only presumption. Thank you.
Either maybe a narcoanalysis or brain mapping. So, which is the authority to see that the person is sound or not? Either you are having your own authority or how you are telling that the person is fit to go for these two tests. Which authority is there? Yes, sir, soundness of the person.
Soundness of the person, we subject him for mental status examination. It is done by a qualified psychologist, clinical psychologist.
Whether he is authorized or what? Authorized to subject them for the testing. Okay, ma'am. Thank you.
First, and even the mission in brain mapping will tell us whether he is mentally fit or mentally unfit.
Okay, thank you, madam.
I've not heard from you those who are innocent. So I feel this scientific method, if it is going to be applied in the society, it's going to implicate more those who are innocent.
Number one, whether there is any violation of human rights when a person is subjected to brain mapping. This question has been deliberated by many brain mapping expert is not interested. Now his brain is being only looked for crime, which is exclusively decided by the probes. The probes are so selective that it will elicit only crime information and no other information. People is to be checked for as an accused, or an individual to be checked as a witness only, or as an innocent. Even then it is possible, right? The various aspects of P300 characters has been studied.
Question. Is there any mechanism in our country to standardize the forensic evidence?
To standardize in the entire process. Number one, the quantification of the parameters deciding neurosis, which is measurable by base, right? He goes into the trance, he reveals. Some kind of a generalization is now possible. So parallel. Is the question addressed to me or to Dr. Malini? To me. Or both?
Consciously aware and process the information. Just watch the photographs being presented. What happens in the brain is being studied. How the neuron, it generates electrical activity.
Remarks. Taking maximum 15 to 20 minutes, not more than that. 3. He said, if matters arise in our law which concern other sciences or faculties, we commonly apply for the aid of that science or faculty which it concerns. This is an honorable and commendable thing in our law. We approve of them and encourage them as things worthy of commendation. This is what is being done by the law over a period of time, accommodating the development in science and the field of technology, and taking the help of science and technology to administer justice. Then comes a question as to these, or mundane questions, routine questions which have been asked. And we know the supposed superior knowledge or experience of the expert is what makes him an expert, and it is his opinion that the judge may have to consider before pronouncing the judgment. As Lawton LJ stated, an expert's opinion is admissible to furnish the court with scientific information which is likely to be outside the experience and knowledge of the judge or the jury. I remember a month back when Dr. Malini was making presentation of her scientific technique of brain mapping to a sea of judges. That Bhopal, the judges with rapt attention were trying to understand the technology involved. And later they said, well, this would be of a very, very, very important scientific tool for us. We may have to know as to what it is, how it could be scientifically validated or legally validated. Well, I need not take you through this particular thing as to who an expert, etc. However, the duty cast on the judge, on the court, is to make every genuine effort to find out the truth. And in the process of finding out the truth, the judge would look at all the available evidences, despite the fact that Section 5 of the Indian Evidence Act says that evidence may be given of the existence of the fact in issue and facts which are declared to be relevant under the Indian Evidence Act. However, for relevancy purpose, you would be looking into the Evidence Act, but for collection of evidence which is going to prove these relevant facts, you may be looking for evidences including the scientific evidence. And to determine as to who that particular expert is, long back in Silver Lock, the court had said, all that you ask is he peritus? Is he skilled? Has he an adequate knowledge or not? And then determine that he is an expert. But this question has always haunted the minds of the courts. It's relevant evidence, but some courts consider that to be weak evidence sometimes. But when the scientific technology or technique has been proved beyond doubt or to utmost perfection, the courts have never looked away from accepting the scientific evidence. As far as reliability standards for scientific techniques are concerned, you find it's excluded if it concerns a topic on which the court is able to form its own opinion. And also, if it concerns the ultimate issue which the court must decide on. And we know it's not the scientific evidence which ultimately decides that particular issue, it is the judge on application of the scientific evidence who would decide the judge. And if this particular piece of scientific evidence is going to decide the ultimate issue, then the court will have to be very, very careful in that. Discretion to exclude evidence that is more prejudicial than probative might also provide a basis for exclusion. Well, you may exclude evidence that is more prejudicial than going to be probative, and that's where the judge is going to decide. However, there are also infirmities of expert evidence. lack of knowledge. You may, as Professor Mohan was informing me today morning in the course of our chat, there are several self-proclaimed experts. Well, self-proclaimed experts cannot be, in the eye of law, under the Evidence Act, be considered as experts for the purpose of giving evidence under the Evidence Act. And how would the judge decide whether he is an expert? Does the judge have an expertise to decide the expertise of the expert? Well, there are. In every instance, the judge has been taking decision unless Section 293 of the Criminal Procedure Code is invoked. Then, inaccuracy of expression. The issues are there, scientific experimentation is conducted, but while presenting the scientific results of the scientific evidence, there may not be appropriate communication, and that would prove costly in an expert evidence. And are there scope for partisanship? If the parties are allowed to bring in experts before the court of law, there is bound to be such partisanship, and the expert might tailor it according to the needs of the